So, good afternoon and welcome to today's program, Estate Planning 101, the basics for higher ed professionals. I'm Nicholas Cunningham, the program manager of LVAIC. We have a great presentation for you today. Estate planning attorney Kalyna Procyk from the Procyk Law Group is joining me today. She will break down the essentials of estate planning so higher ed employees can learn without all that legalese. Before we begin, please be aware that we are recording this session. We'll stop the recording during our Q&A session at the end to respect everyone's privacy. Please put your questions in the chat throughout the presentation, and we will get to them at the Q&A session. And now I'm going to turn everything over to Kalyna.
Nick, thank you so much. So as Nick said, my name is Kalyna Procyk. I'm an estate planning attorney. I am out of Bethlehem, Pennsylvania, but I see people online. So I see people all over the state of Pennsylvania and also all over the state of Illinois. I am originally a Chicagoan, grew up in Chicago, so still maintain a practice there as well. So today we're going to talk about estate planning for higher ed professionals. Just to give you a little sense of my background, my family and I, we've been in the Lehigh Valley for about 15 years now. I started off my career as an attorney in Chicago. I worked for a couple of the very large international law firms. And then when we came here and we moved here because my husband got a job at Lehigh. So this is a picture of him and our two kids who are now a little bit older and more glamorous. They're 17 and 13 years old. And this is my husband, Nick, who some of you may know. He's an art historian at Lehigh. We moved here and I also spend a little bit of time in higher ed, working at Muhlenberg College and then teaching a little bit at Lehigh as well. So I love working with higher ed professionals. I have a special soft spot for people that like to educate college students. So I'm really happy to be here. Um, I have an estate planning practice, so this is all that we do. I don't do criminal work. I don't, I can't bail your second cousin, help them get their DUI dismissed. This is all that I do and that we at the firm do, and that is so we can be the absolute best advocates for you guys. We know where all the loopholes are. We know where all the pain points are. So you can make sure that you protect your family members. I got into estate planning actually in part for a very personal reason. So a few years back, my mom had passed away, and this was right as I was creating the firm. And it was unexpected. My parents had been organized at one point in their lives, and then they got older, and when she passed away, things that we thought had been taken care of had not been taken care of. And even though I get along really well with my younger brother and younger sister, it was really tumultuous, and it was really emotionally exhausting because of those gaps in their existing estate planning. So a lot of conflict, and at that point, I decided I had my why and I had my marching orders. I had the skills and tools to help you guys avoid the same situation that I found myself in. So I decided that was what I was going to do. So that's a little bit about me. Now, I want you guys to consider, you may be wondering, who is this for? Am I in the right place? If you want to be sure that you don't leave a mess for the people that you love, you're in the right place. Estate planning is for you. So I also want you to consider for a moment, why did you come here today? So maybe you came here because you want the comfort and assurance that your family members would be taken care of if anything happens to you. Maybe you wanted the peace of mind knowing what would happen to your assets after your death. Maybe you're most concerned about taxes and you want to be sure that you are saving the most on taxes and fees so that your family members or your loved ones get the maximum amount of money possible. Maybe you're concerned about self-care. You want to be sure if you end up in the hospital that your choices for your body will actually be honored. Maybe you're you're really involved in a community and you want to be sure that some community gets supported if something were to happen to you. So if you came for any of those reasons, you're here for the right reasons. We're going to talk about a bunch of different issues. And then as Nick mentioned, at the very end, we'll have Q&A. So go ahead. I can't see the chat, but go ahead and type your questions into the chat as things come up. And then at the end, we'll have a chance for discussion. And I think he'll release the microphones. Okay, so one of the things I want you guys to consider is who will step forward? All right, if you were in an accident tomorrow and something happened to you, who would be the person that shows up to the hospital and says, I'll make the decisions? They'll raise their hand and they'll say, I will help. And maybe if you're married, you would say, well, that's my spouse. Well, how about if your spouse is in the car with you? Who would be the person that steps up? The person that steps up is usually nearby. So if you have family members that are far away, it might end up being a neighbor. It might end up being a friend. It might end up being somebody that you want to be in that role, and it may end up being somebody you don't want in that role. So I just want you to consider that for a second and just feel the tension there. Is the person that would step up, is that the person that I actually would want in that role? There are going to be a few different times where I'll ask you to feel that tension. And you know what? I did forget, as we're getting started here, I did forget one thing. When I do this presentation in person, I have something I call the purple worksheet because it's actually purple, but because we're online, it's just a link. So I'm going to ask Nick to drop the link to the purple worksheet into the chat. And I would like you guys to open it up. You can open it up on the phone or on the computer and filling out this purple worksheet. This is what is going to ensure that you get all of your questions answered. So please fill out the purple worksheet as we go along. And at the very end, if you turn it in to me, I'll have a special gift for you. Okay, so purple worksheet. So question for you, when was the last time you reviewed your existing plan? So there are two answers to this question. Either you do have an existing plan. At one point, you know, you got some documents drafted up, a will or a power of attorney or a living will or guardianship documents. Either you have something like that or you don't have something like that. Now, if you don't have any documents, then the state has a plan for you. The state, in the state statutes and regulations, has a default plan. And that's a plan that you may or may not like. A lot of people don't like it for a lot of reasons, but it will be implied for you. So what would happen if you don't have a plan? If you're incapacitated, so you end up in the hospital, your loved ones, in order to get access to, make decisions about you or, make financial legal decisions on your behalf, they will need to, first, someone will need to raise their hand, or sometimes what happens is a couple different people raise their hand, and then that's built-in conflict right there. And then they'll have to hire an attorney, go to court, and get the legal right to make decisions for you granted to them. All that is expensive. it can take a while and it's laborious. And at the end of the day, the right person might not even be appointed. One of my colleagues was telling me a story out of Arizona where there was an elderly gentleman. His home care worker was, playing tricks on him. Got a power of attorney granted to him, and the son came in from California and was trying to make sure that his dad was taken care of. So he went to court, tried to get the power of attorney. And because he was a business owner and his credit had taken a hit, he didn't have a good credit score. The judge said, "Oh no, you can't be the power of attorney. You don't have a good credit score. You're not trustworthy." So, once issues are out of your hands, they're in the hands of a judge, it's not clear what the outcome will be. So where you can, whoever you choose to serve in these roles is going to be better than who a judge would have selected, because a judge doesn't know you. So also, if you don't have an existing plan and you pass away, that process is called probate. Okay. And we'll talk a little bit about we'll talk a little bit about the probate process in a second. So planning for your death, what does it typically look like when you are, trying to put some estate planning documents in place? And I have to tell you, I'm actually not a huge fan of the term estate planning in general, because I feel like the emphasis is really on the documents. And estate planning is really not just the documents. The documents are there to memorialize all of your decisions. It's really in the counseling and in the conversations, in an expert like myself asking you to unearth some of the unknown unknowns, the questions that you wouldn't know to ask, to ensure that we have a comprehensive plan that's tailored to you guys. And it's not just a bunch of cookie cutter documents that, are drafted by ChatGPT or LegalZoom, or, sometimes your buddy down the road that also does DUI work and criminal work as well. So a lot of times with traditional estate planning, you do see one-time transactions, or you'll get form documents. Sometimes they avoid probate, sometimes they don't. Sometimes they avoid estate taxes, sometimes they don't. A lot of times they're leaving assets to your heirs unprotected. And a lot of times there's no ongoing legal guidance. It's just a one-time transaction. And the other issue here, a lot of times when we're talking about documents only estate planning or documents only planning, there's a very high potential that your assets or some of your assets will end up going to the Department of Unclaimed Property. In the state of Pennsylvania, we have between $2 and $3 billion in the Department of Unclaimed Property. In the state of New York, they have now between 14 and 16 billion dollars in that department. And a lot of it gets there because at the time of your death, your loved ones did not know of the existence of some life insurance policy or some bank account, a CD you opened up at a bank that you don't usually bank with. And then that it goes by the wayside. So yeah, I try to do things a little bit differently so that you guys actually have a plan that works, that's customized to you, and your family members have somebody that they can go to, that has been pre-vetted, that like, and trust, as opposed to being confused and uncertain about what the next steps are. and whether this plan is actually going to work. So, okay, let's talk a little bit about probate. So we talked a little bit about what happens if you become incapacitated, you end up in the hospital and you don't have a plan. Or your plan is so old that it's stale and, it doesn't work for you. If you pass away, that process is called probate. Okay. A probate is a lawsuit that essentially your estate files against itself for the benefit of creditors. And I'm sure talking with your friends and colleagues, you'll hear a lot, about probate, how to avoid probate, don't want to go through probate. How do we do this? And we have different tactics, depending on, what your assets are, how you own them, what your family situation is, etc. So there are several reasons why people don't like probate. Probate is a long process. So your estate is opened up and, everything that's held in your name only, then is, has to be put in an estate account. It's essentially frozen. It cannot be distributed for 9 to 15 months minimum. Okay, so you can't distribute it out to the children. If somebody is relying on that money or getting access to that money, too bad, they can't get it. And so if you need some funds to renovate a house before it goes to sale, that means someone else needs to front that money because it can't get paid out until the whole process is over. So it's lengthy. There's also a lot of bureaucracy associated with it. You have to hire an attorney. You have to go to court. The attorney's fees and various executors' fees, there is a schedule in Pennsylvania that is typically relied on, and it is fairly expensive. So, it can be anywhere between 2 and 8% of the value of the estate. We usually take 5% as a reasonable middle ground for how much the probate process could cost. And that includes the executor's fees, attorney's fees, appraiser fees, bond premiums, creditors, filing fees, etc. So this adds up. And this is one of those fees that layered on top of other things we have in Pennsylvania, inheritance tax, etc., can really make this process quite expensive. So anytime you're going to court, it is costly. It's going to be costly. So, a friend of mine was telling me about one probate. Literally, the only thing in that probate was $1 million home. That's it. And attorney's fees ended up being $30,000. The executor's fees were $25,000. So it's, $55,000 right there. Okay, another thing people don't like about probate, it's public. So if you know of someone that has passed away, perhaps one of your neighbors, and their estate went through probate, you can go down to the county recorder's office, Northampton County, Lehigh County, Berks, Montgomery. You can go down to the recorder's office and you can pull their files. So you can read their wills, you can see who got what. And some people don't care, but for other people, it's very invasive. And this is another place where, unfortunately, it is the scam of some criminals to go down to probate court, identify if someone is a vulnerable party. So either they're very young and they've received an inheritance, or they're old, or there's some complications and vulnerabilities there, and they will target them for scams. So that's another reason why people don't necessarily like probate. Um, okay, also, um, your beneficiaries, um, uh, they may receive, if you have you don't have a plan at all, or you just have a very simple will, your beneficiaries may be receiving their assets outright and unprotected. So that means young people who are 18 years old, you know, they have the ability to take over their inheritance. And sometimes that is not the right time for them to be doing that. All of you guys, you're college professionals, you've seen young adults that are age 18 to 25. And sometimes getting a big dump of money at that time in your life leads to more harm than good. I'll tell you one story about that a colleague told me. A family, the husband and wife were divorced. They had three sons. One son was 18, one was 24, the third one was 26. The dad passed away of a heart attack unexpectedly, and he left all three of the kids $500,000. So 18-year-old promptly quit college and decided he wanted to spend some time finding himself in Bali. So took that money, booked a plane ticket, and his mom over the next years was desperately trying to get him back just to finish his college degree. Next child was 24 years old. He promptly proposed to his college girlfriend. They got married, and he paid for a house in Connecticut in cash. He bought it outright. So that was bought jointly in their names. 3 years later, she divorced him, and she took half of that asset, half the house. Then child number three, 26 years old, he had already struggled with some drug and alcohol issues. And with the addition of the money, that really added fuel to the fire. And so it took him a long time to get out of that situation as well. So, children inheriting assets at the wrong time or inheriting in a way that aren't protected, that can cause problems. Okay, now I'm just going to briefly say something about kids. If anybody here has kids under 18, or maybe you have grandchildren that you sometimes babysit, if you have, even if there are long-term guardians named in the will, if there's a couple, goes out to dinner and gets into an accident, eventually the police end up being called. And if the police come to the house, whoever is sitting with the kids doesn't have a temporary guardian document, the police will take the kids out of the house and put them into foster care while guardianship is being settled. So that's really not a great solution for many parents. A lot of parents don't know about that. If a traumatic event happens, most of the time you have people that will step up and take your kids into the house. So putting some temporary guardians in place is a really important thing. Okay, how about healthcare directives? So perhaps you guys have heard the story of Terry Schiavo. Terry Schiavo was a young woman, 26 years old. She was in a persistent vegetative state after having a heart attack at the age of 26. She had had a conversation with her husband about removing her feeding tube if she was ever in a vegetative state, but her parents disagreed. And so for 10 years, she was in a vegetative state, kept alive by the feeding tube, until finally the courts agreed with her husband and allowed the facility on his direction, to remove the feeding tube. And then she was allowed to pass peacefully 5 days later. So if that's a situation that is uncomfortable for you, or you would not want something like that, then you should really think about a living will because her entire situation could have been avoided with a living will. Let's talk about some common planning techniques that do not necessarily work. Okay, there's a time and place for all of these things, but they can be problematic too. So, owning property jointly. Sometimes people say, "Oh, okay, well, we'll take care of our estate plan by putting the kids on the house. We're just going to add them to the deed." It'll avoid probate, make things easier for everybody. This is problematic because, yeah, okay, at the time of your death, the kids get the house. However, when those children go to sell the house, they will be on the hook for the original cost basis of the house. So whatever you paid for the house, maybe that was $100,000 in 1980, and now this being the Lehigh Valley, that same property could be worth $800,000. So they will have to pay capital gains on the difference between the 800,000 and the 100,000 if you just gift it to them, if you put their name on the deed, versus if they inherit it, then they get what's called the step up in basis. And so their new basis is the $800,000 if they inherit it that way. So when they go to sell it, they don't have to pay capital gains on, $700,000 of appreciation. So another one is designating a beneficiary. Sometimes on various IRAs and bank accounts, you can do a beneficiary designation. People will say, great, super easy. There are a couple of things that I have seen happen there. One, people don't check their beneficiary designations. And so, the TD Ameritrade was absorbed by Charles Schwab. And if you didn't double check that your beneficiary designations were updated, then you don't have beneficiaries anymore. Another issue there is, and so that's going to kick the whole estate into probate. Another issue is if you're just designating a beneficiary, that money is going to them outright. So there's no asset protection around it. If they end up in divorce court, that money is not protected in divorce. That money is not protected from creditors. It's not protected from bankruptcy if it goes to them outright. So signing a will, sometimes people think, oh, I signed a will, that avoids probate. Nope. Merely signing a will not avoid probate. So what is one technique that we do use to avoid probate? Okay, what's a possible solution? One of the things that we do is we will set up a revocable living trust. Revocable living trust is one way to avoid this court process. So, but simply setting up a trust, that's not enough. You actually have to fund the trust. If you don't fund the trust, then you just have a very expensive stack of papers. So how do you fund the trust? You fund the trust by executing a deed so that the deed goes into the trust. So let's back up for a second here. A revocable living trust is like a shopping cart. While you're alive, you push that shopping cart. It's revocable, so it's very flexible. You can change the terms. You have full control over it. You can put things in, you can pull things out. You can create it, you can destroy it. And so into this shopping cart, you will put various things, a deed to your property. You might retitle investment accounts into the name of the trust. Maybe retitle some bank accounts into the name of the trust. You assign your personal property, like your jewelry and your art collection and your books and your cars into the trust. life insurance policies and retirement accounts, those are owned in your name, but you might have the trust as the beneficiary on it. And if you already have a trust and you haven't looked at it in a while, then it's a really good idea to take a look at it. You really should be taking a look at your documents, your existing estate plan holistically every 5 years, every five to 10 years, because there's a lot of stuff that might happen. Right now, you guys are in the thick of your lives. There are a lot of things that are happening. People are coming together, people are separating. You're purchasing properties, maybe you have a business. Some people in your life are passing away, other people are being born. So it's a very dynamic time. And during those times, really good to review the plan every 5 to 10 years. So, okay, we talked a little bit about inheritance, and ensuring that if somebody's getting property, then you have the option of putting some asset protection around it. So let me give you another example of where you might want an asset protection trust. Okay, sometimes people will leave things to their spouse in an asset protection trust. Why would you leave something to a spouse in an asset protection trust? Two reasons. One, if you are in a high litigation field, or you own real estate and you don't want your spouse to be left with a bunch of lawsuits, you want some money to be protected, that's a great reason. Second reason is the trophy wife pool boy situation. So let's say you're married, two of you are in an accident together, one person passes away, and the other person has a traumatic brain injury and has a change of personality. And all they want to do is run off with the pool boy or the trophy wife or some home healthcare worker. And you want to go to Vegas and spend everything, and then spend every money, every dime that the two of you have built together, and then no money gets left for the children. And I'll tell you that it happened to a neighbor of mine growing up, where the dad passed away from a heart attack at a very young age. Mom, in her grief, got married to a guy who wasn't a terrible person, but just loved the good life. And then a couple years ago, during COVID, she passed away, and the kids went to the stepdad and said, "Hey, can we get that money that our dad left us for college?" And the stepdad said, "What money? Oh, you and your mom, myself and your mom, we spent it on vacations. There's no money." So, unfortunately, it does happen, and there are ways to solve for it. How about estate taxes? So there are two main taxes that you need to keep your eye out for. One is the federal estate tax exemption, which is $15 million right now. So if you have more than $15 million, you will need to pay 40% on anything that gets passed to anyone else. So anything above 15 million. So at that, for a federal estate tax, most people don't have an issue. However, it's at 15 million right now. So this number that's on the screen, that's from previous year. It's at 15 million. However, there is legislation on the table to bring that down to $1 million. So now, this number goes up and down. 15, 20 years ago, it was down at $500,000. So you do need to keep your eye on the federal estate tax and federal estate tax exemption. Here in Pennsylvania, we have a unique situation in that we have an inheritance tax as well. we're one of only four states remaining that has an inheritance tax. Everybody else has repealed theirs. So if you want to leave something to your spouse, tax is 0%. If you want to leave something to children, your children or grandchildren that are 21 and younger, 0%. If they're over 21, it is 4.5%. If you want to leave something to a sibling or sibling-in-law, it's 12%. And finally, nephews, nieces, step-grandchildren, your neighbor, 15%. So if you're following along here on the purple worksheet, on that little link, click the box that if you're worried about this, click the box or check the box that says, I need to avoid estate taxes. All right, we talked a little bit about unclaimed property. This is a good one for higher ed folks, because I find higher ed folks sometimes have property either in the form of research, scholarship, books, and also memories, humanistic values, experiences that are not captured in traditional estate planning documents. So one of the things that we do at the firm, if people are open to it, and I would say the majority of people actually elect to do this, is at the end we do an interview. And I send you questions beforehand. You don't have to prepare, but sometimes we'll tweak the questions depending on what area somebody worked in or had expertise in, and we'll do an interview asking about these things. I'll tell you, when my mom passed away, I had a bunch of voicemails from her on my phone, and they're 7-second voicemails with her just saying, "Hey, Kalyna, it's your mom. Give me a call back." And I'll tell you that that's one of the most precious things to me. I listen to those voicemails over and over again because it's just a little taste of her. So boy, what I would not give if I had a 30-minute recording of her talking about her values and insights. So I definitely have more resources on this topic as well. So, okay, how to get started and how to get it done. I'll tell you what we do at my firm. Usually what we do is our first step is a 2-hour working session. And I call it a life and legacy planning session. During this life and legacy planning session, we do a couple different things. So it starts with an inventory of your assets so that if something were to happen to you, your family would know where your assets are, what they are, how to find them. And then during this working meeting, we cover a few different topics. So we talk about your goals and your values. We talk about your family dynamics and the family ecosystem. We talk about the assets, so how things are owned and who owns them. And then we identify gaps. So we'll talk about what the opportunities are, where the gaps are. And then at the end of that hour, you'll prioritize those gaps. You'll tell me what's important, what's not. And if we feel like there's a good fit between us together, and we want to work together, then at that point we can decide to work together. And then we spend the second half of that meeting actually doing planning and making elections. So, let's talk about cost. How much does estate planning cost and how much does life and legacy planning session cost? Usually the life and legacy planning session to meet with me, it costs $950. But if you are willing to take a couple steps I will give you a discount in that if you want to come and talk to me. So in general, how much does estate planning cost? I would say between $3,000 and $9,000 on average. Most people end up somewhere in the middle. Um, you're only going to choose to do something if you actually save more money in the long run than you spend. Um, but I would say this is a reasonable estimate. And I can't tell who's going to land where. You have to make some choices for what makes sense for you. So, because you attended the seminar today, I'm offering this golden ticket. And really, the reason why I do this is we are all our own worst enemies when it comes to estate planning. It's a topic it's hard to consider. You're considering your own mortality. There can be some sticky issues. And so I'm going to incentivize you by giving you $1,000 of estate planning services. So, what would you have to do to take advantage of this? First of all, complete the purple worksheet. So, Nick, if you could put that purple worksheet link into the text chain, again, that would be great. So put in your name, address, phone number, email, and couple of the issues that you see coming up in your life. And then there's a second link. And the second link is for a consultation for 15 minutes. And in that consultation, then one of my staff members will walk you through getting set up with a life and legacy planning session. So I'll give you this $950 life and legacy planning session for $250. So discounted rate. So I would highly encourage you guys to do this. Your action items are fill out the purple worksheet, schedule a time, 15 minutes to meet with Erin, and do your homework. Do your homework before the session. That's the other piece of this. So the homework, it's not super onerous. There are questions about your values, some questions about your family, and then some questions about the assets. And it should take you, maybe an hour or two over a weekend. Okay, some of you don't need to come in to meet with me. If you really don't have any assets and you have 3 people in each category that might be able to serve as your executor, guardian for your children, power of attorney, you have no complications and you're naturally organized and you're going to get this stuff done. If that's you, on your purple worksheet, make a note, I want to DIY this, and I'll send you some information on how you can DIY your own estate planning. Okay, so questions. This is me.
All right. Yeah. Well, thank you so much, Kalyna. Before we get to the Q&A session, I just want to thank you, Procyk Law Group, for such an informative presentation. And now I'm going to stop the recording for our Q&A session.
Okay.